Hello, everyone, and welcome to our webinar. We're going to give a couple of seconds for everyone who registered to join this live session. We have people coming in. Tonight's webinar is on Guardian Advocacy 101, which will be covered by the lovely Regina Drainin. She is a probate and guardianship attorney here at SJF Law Group. I'm Jenny Lamb, and I am the marketing director here at SJF Law Group. I'll be moderating tonight's webinar, and I'll be assisting behind the scenes during the webinar. I want to briefly get into some housekeeping rules before we get started. We have our chat box on the right side of your screen, so feel free to ask your questions in there. I will be monitoring the chat box. And throughout the webinar, I'll also be releasing a few different polls to check in with our viewers. In fact, I'm going to release our first poll now. Which best describes you? Please let us know by selecting one of the answers. We would love to know more about our audience tonight. Let's see, everyone's answering. A lot of parents joining. Thank you, everyone, for joining tonight. And I'm going to hand it over to Regina now.
Thank you. Good evening, everybody. My name is Regina Drainin. I am an attorney here at the SJF Law Group. I am also a parent of a child on the spectrum, and I am also a caregiver. So I understand this from all different perspectives. So tonight we're going to talk about Guardian Advocacy 101. It's just going to be a basic overview of what this is. Most people know about guardianship, but they don't know about guardian advocacy and what the differences are. So hopefully you will come away from this with some more knowledge about guardian advocacy and whether or not that's appropriate for your family. So let's get started. Little plug for us. We are located in Plantation, Florida. We handle estate planning, probate administration, trust administration, guardianship, prenuptial and postnuptial agreements. We can also help you with your own estate planning to make sure you make the proper documents to take care of your loved one who would be in a guardianship or guardian advocacy. Although we're in Plantation in Fort Lauderdale, Florida, we do handle all over the state of Florida. All right, so let's talk about what is a guardian advocate. A guardian advocate is someone who is appointed by the court to represent a person with developmental disabilities if the person lacks the capacity to do some but not all of their tasks of daily living. Tasks of daily living are getting dressed, eating, making food, making social decisions, bathing, just what we do in the daily course of a day.
Real quick, I'm going to share a poll in regards to this question. How familiar are you with the concept of guardian advocacy?
Well, let's first start off with what constitutes a developmental disability. The guardian advocacy statute is Florida Statute 393, and it was developed specifically for adults with developmental disabilities. They're not totally incapacitated, but they need some extra help. In order to qualify for 393, the most important is they must have been diagnosed before the age of 18, and it must be documented somewhere. And we'll talk about that a little bit later. The conditions or disabilities that are included are intellectual disability, low IQ, cerebral palsy, autism spectrum disorder. I know they've kind of combined that all, Asperger's and such, it's all into the autism spectrum disorder. Spina bifida, Down syndrome, Phelan-McDermid syndrome. I've never encountered that, and Prader-Willi syndrome. I've never had a client with that, but those are some genetic disorders that affect a person's developmental status. So here's the problem. The majority of you are parents, so we take care of everything until our children turn 18. Once anybody turns 18, they are legally an adult and they can make their own decisions. Sometimes the parents can kind of get away with making decisions with familiar doctors, with the school, etc. So sometimes we get people who are, my child's 17, we need to do something, or we get clients that are the person is 30 and now they're having a problem making decisions. So my suggestion is try to do this as soon as possible to your, I'm assuming your child or your family members or friends when they reach the age of 18, to allow someone to step in and make medical and financial decisions on behalf of their disabled child, family member, etc. What's the difference between guardian advocate and a guardian? So I mentioned guardian before, guardianship. A guardianship is a totally different statute. It's for people who are declared incapacitated by the state. In a guardian advocacy, we are not declaring the person as incompetent. What we are saying is there are some challenges, there are some developmental disabilities that were diagnosed before the age of 18, and they need extra help. They need guidance. They need someone to step in and protect them. So it's more of a streamlined process, if you will. The person is not declared to be incompetent. It's just they have this diagnosis. Here's the documentation. Please delegate those rights to the guardian advocate to allow them to act in their best interest. One reason that's important is because even in a regular guardianship, the court always looks to the least restrictive alternative. So for example, if a person has a power of attorney or a healthcare surrogate and they're found to be incompetent, the court will look to see, hey, are there any other documents in place that could help this person? Guardian advocacy is also a least restrictive alternative to guardianship. So this is important to know, that we try to do the least effect on someone's rights. Another big question is, to do a guardian advocacy, do I need an attorney? For a guardianship, yes, but what we're focusing on tonight, no. If you are just looking to be the guardian advocate of the person, which is to make medical decisions, social decisions, educational decisions, mental health decisions, you do not need an attorney. You can be the representative payee for the person, for the developmentally disabled adult, without having to be guardian advocate of the property. If for any reason they do have property, if they've had an inheritance, or if they just have some funds, you will need an attorney if you seek to be guardian advocate of the person. The courts are a great resource for self-help forms. And at the end, we'll also give you some resources that I've located online. It's a Florida statute. So just because it's from the information's from a different county or circuit, it's still applicable and the basics are there. Of course, as an attorney, I do suggest you contact an attorney. It is a legal process. You still have to follow all the same rules. You have to deal with the courts. You have to deal with the judges. You have to deal with the clerks. So I do suggest you get an attorney. One of the things that people sometimes do is they have an attorney help them set this up. They get appointed, they do their initial paperwork, and then their attorney can withdraw. At that point, their attorney, they don't need their attorney anymore, and they can act on behalf of the developmentally disabled person and continue on the process. So that's just something to keep in mind. Okay, so we talked about what the qualifications are for a developmentally disabled adult. Now we're going to shift to what are the requirements to be a guardian advocate. You have to be over the age of 18. You cannot be a convicted felon. You have to be a resident of Florida unless you are a relative. You cannot be a provider of healthcare services to the ward, meaning you can't be hired to give healthcare services to the ward. And you have to be able to fulfill the duties of a guardian. If you are incapacitated or not physically or mentally able to take care of the person, you would not qualify. How long does the process take? Well, initially here at SJF, you would come, we would have a consultation, you would decide if you're going to hire an attorney, intake is done, paperwork is done, documents are drafted. Okay, that varies if you're doing it on your own or if you're working with an attorney. Once the paperwork is done, you have to file the paperwork with the courts. Typically, the initial filing of the documents to the signing of the letters and orders should take about 6 weeks. Of course, sometimes less, sometimes more, but it's at least 4 weeks. Hopefully, we get it done by 6. So now you've been appointed as guardian advocate. What is it you need to do now? You will continue to do what you've always been doing, except now you'll have a piece of paper that will allow you to do it. You will continue to help them get their medical care, government benefits, etc., act as their advocate, be involved in their daily lives. You will help them manage finances and contracts, again, if you're being guardian advocate of the property. Every year there are documents you have to file with the courts, which we will explain in a future slide. Okay, so step 1, you have either contacted an attorney or you're thinking, hey, I'm going to try and do this on my own. So this is the information you need to gather in order to fill out the information. You need the petition to appoint the related forms, which we'll go over. You need names and addresses of the next of kin. That would be mom or dad, brothers and sisters, aunts and uncles, anybody who's involved with the care of the developmentally disabled adult. You need to provide the name, address, and phone number of the current physician. That just provides information to the courts. We look for the date of diagnosis of the developmentally disabled person. It may or may not be writing. We all know as parents they were 4, they were 5, they were 2, etc. We need to see an amount and proof of assets or income. So if your child is getting, I keep saying child because that's typically what the relationship is. Every January, you would get a letter from SSI regarding what their annual benefits are. It's good to have a copy of that to provide that information. The most important thing is some sort of document. And I know as parents, we all have that big folder of all the information from when our child was first diagnosed. And there has to be somewhere in black and white a letter, psych report, or IEP stating exactly what the developmental disability is and that it was diagnosed prior to the age of 18. The diagnosis has to be one of the diagnoses that was on earlier: cerebral palsy, autism spectrum disorder, Woolley-Prater, Down syndrome, low IQ. And I've had cases where we've gone to court and some of these disabilities have physical characteristics. And we're sitting there in court and the judge is saying, I know this person has this, but I still need to see something in writing. So typically the first or second page of your IEP will have a diagnosis, and that's all you need. And just a reminder too, that at least in Broward County, this is a confidential proceeding. It's filed in mental health court. So because it's hard, we don't want to put out information about our family and our children for just anybody to read. So it is a confidential file. Only certain people can see it. Things will be redacted. Your privacy will be maintained. Okay, so now the hard part is complete all the necessary paperwork. Again, the court will walk you through it as much as they can. They can't give legal advice, but they can direct you in the right direction. You gather your paperwork, you file the forms with the clerk of courts. You can either go in person or you can register on the e-portal, which is myfloridacourtaccess.com. Register and you can upload and scan in the documents. That's the preferred way of doing things. And you do not need to be an attorney in order to do that. We talked about not being a convicted felon. So one of your requirements is to get electronic fingerprints, which gets submitted to the court. And what they do is they then run a Florida Department of Law Enforcement, FDLE, background check. You also, as part of the necessary paperwork, you fill out an application, and it basically looks like a job application. The most important part of that is it asks, have you ever been arrested for a felony, something other than a felony? Have you ever been convicted, etc.? What they do is when they get that Florida Department of Law Enforcement background check back, they compare it to your application to make sure everything matches and that you've disclosed. In my years of experience, I've seen a lot of people don't include certain things because they think they've been sealed or expunged. They find out. So you could have done something that was sealed. You really need to disclose it. If something comes up that doesn't match, I find typically the court will call and say, hey, you need to redo your application. They're not trying to disqualify you from being a guardian advocate. They will work with you, but disclose, 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 so there's no surprises. Okay, so this is what you're going to take to the clerk of courts, or you're going to work with your attorney on. Petition for appointment of guardian or co-guardian advocate. Basically, that is stating your information. We're going to say your child's information, what their diagnosis is, what things they need help with. They need help with some things, but not others. For example, they need help with medical decisions. They need help with educational decisions. If two parents are, if one of them is applying to be guardian advocate of their child, the other party has equal standing, if you will. They're on the same level to be appointed. So we ask the other parent for a waiver and consent saying, hey, I know this is going on. I'm okay with the other parent being appointed as guardian advocate. That's called giving them notice because they are an interested party. They do have a right to know what's going on. You will also sign an oath of guardian advocate. Basically, it's, I swear I'm going to listen to my attorney. I'm not a convicted felon. If I move, I'm going to contact the court, and I'm designating this person as my agent. What that means is if, let's say I was your agent, if my office receives paperwork related to the case, it's the same as if you've received the paperwork. And then every county is a little bit different. It's a little frustrating because this is all based on Florida statute, but each county has their own nuances. Broward County here, for example, has what's called a mandatory checklist, which is one page, asks the same information that is on the application, but for their purposes, it triggers a background check. Again, every county is different. The best source is to contact your clerk of courts and find out what nuances they have. Okay, so you filed with the clerk of courts. You have accomplished the hardest part of everything. You will be assigned a case number. You will be assigned a judge. You will get paperwork in the mail. The court will appoint the developmentally disabled person a court-appointed attorney. The reason for that is we are looking as petitioners to affect their civil rights. We've all watched Law and Order. We've all watched different cop shows where they say you are entitled to counsel. It's kind of the same thing here. They will appoint an attorney to represent your child just to make sure due process is followed, just to make sure your child's rights aren't being violated. That attorney will reach out to usually you because you're the point of contact for the child. Come and meet with your child. During COVID, most people were doing it by Zoom, but I think it's getting more in person. They will present the paperwork. They will go over the paperwork with your child and kind of explain what the proceedings are. Everybody, the petitioner, the next of kin that we talked about, the other parents, they will get what's called a notice of hearing, which has all the information about when the hearing will be, where it will be, who it will be before, how you access it. Most of these hearings are on Zoom still in probate court. We really haven't gotten back to court. And this is held, the mental health division is through probate court. So it's probate and guardianship court. Again, usually hearings are via Zoom. So you appear at the hearing. In Broward, we have our hearings before what's called a general magistrate, which is basically a junior judge. It's an appointed position. They have more time to deal with these issues. So the judge will say, I want general magistrate to hear this. That way we have more time, it's more relaxed. Dade County, the judge, I believe the judges hear it. Every county is just different. But the people who are involved in these hearings and these procedures, for the most part, are very aware of the fact how hard this is as a family member, how hard this is talking about your child. And it's much less formal. It's much more casual than like what you see on TV. Nobody's yelling. They're very mindful if you get emotional, if you need to take a break. So in Broward, we would have a hearing before the general magistrate. The attorney for your child has the option of waiving your child's presence. The reasoning for that is, we're talking about your child, and you don't want to upset them, and they may not be able to contribute to the hearing. So their attorney can make a judgment call and say, hey, I'm going to represent this person. That's typically what I do. I've had a couple where the child was super excited to go to the courthouse. So come on in, you come to the courthouse. If you have a general magistrate, they will write a report that gets sent up to the judge, who basically stamps it and says, yes, I agree with the findings. I agree that the general magistrate said that mom should be the guardian advocate. It's an order. At that point, we have to, we submit the order appointing guardian advocate and the letters of guardian advocate to the judge. Sometimes you mail it in, sometimes it's uploaded through a portal. They sign it, it gets scanned in, it appears on the docket. At that point, you can get what's called certified copies of the letters and the order, and that really gives you the power. The order says, we're going to appoint mom and dad as the guardian advocate of child. The letters delineate what rights have been delegated to you. So again, remember, we're not taking rights away. We're not saying they're incompetent. We're just delegating them to you. You will then be required within 4 months, you have to take an 8-hour online class. It's on demand. It's not that you have to sit in a classroom for 8 hours. I think the last hour is at a set time, but the other 8 hours you can take whenever you want. And that has to be done within 4 months. You will get a certificate of completion, which you submit to your attorney, and they file it to show proof to the court, or you file it with the court to show that you met your requirements. Within 60 days of the date those letters and orders are dated, you have to do what's called an initial plan. These forms, again, are all on the court websites. And basically, the initial plan is telling the court what you intend to do to care for your child for the next year. What their doctors are, where they're living, what your plan is. The biggest thing here in Florida too is evacuation, right? What are you going to do if there's a hurricane? So that gets submitted within 60 days. If your child has property, we also have to do an initial inventory, which is basically a snapshot of what they owned at the time of the letters and orders. And then every year, we have to do a new application, which just, again, updates information with the court, and a checklist. Broward County has a checklist. Not every county has a checklist. And by filing that application, it will trigger another background check. So you only have to do your electronic fingerprints once. And it doesn't matter if you've done it for something else. I get that a lot, like, oh, I'm a teacher. You still have to go get these fingerprints done. So here's a bunch of links and info. If you Google Guardian Advocate Florida, a bunch of information will
I'm going to share the links in the chat box, Regina, so I'll have it for everyone. Here's the first one. And then also, I'll release our last poll. Please let us know what your biggest concern is regarding guardian advocacy. 6 links. And then, Regina, there's a couple questions in the chat box for you.
Okay. All right. Let me see. How do I check? Okay. Okay, let's see. If you've been your child's guardian a few years ago but didn't know how to renew, you had to renew yearly, is it difficult to start the ball re-rolling? No. During COVID, at least here in Broward County, everything was kind of suspended. So if you were not in compliance, there weren't any hearings. So the cases still remained open. Basically, what you need to do is just get caught up. So let's say you had done your initial inventory and your initial plan. There are accountings that were due, or probably for the most part, just plans. It kind of sounds counterintuitive, but you would have to go back. Let's say you got appointed in 2022. You would have to do, your initial plan would have been from 22 to 23. So you owe the court 23 to 24, 24 to 25. And the most important part of that is they require a physician's report every year. Basically, it ensures the court that they're being seen by a doctor, and it gives them information about whether or not there's rights that can be given back. But I wouldn't worry about it. It happens all the time. Just, you can fix it. It's really not that big a deal. Nobody's going to shame you. It's just finishing the paperwork. So don't ever feel bad about it. We're all human, and COVID changed everything. So you just need to kind of step back in where you were at and keep going. Okay, let's see. Does the other parent have to be given notice if full custody has been awarded to the caretaker parents? This is where there's a difference between custody and parental rights. So if someone's parental rights were terminated, no. But if there's full custody, it would depend on what the paperwork says. But for the most part, I believe they would have to be given notice. That being said, if they've given notice of the hearing and they come to court and say, I want to be the guardian advocate, you would say, here's the paperwork from our divorce or dependency case. I've been in charge. And that would be considered evidence to support your position. So again, it's the famous legal answer, it depends. But you have to look at, was it full custody or was it decision making? But again, you just have to provide the information and state your case. All right, let's see what we got. If there is a potential inheritance down the road, but no assets to speak of, can a guardian advocate guardianship be changed later, or should an attorney be retained from the start? That's a really good question. It really depends on what you think. No, you don't need an attorney from the start. And what'll happen is, so let's say there's an inheritance from the grandparents, okay? The trust, let's say there's a trust or they're going through probate. That person, the attorney who's handling that, because you need an attorney for the probate, should say, hey, this is going to somebody who's in a guardianship or a guardian advocacy. They need a guardian or guardian advocate of the property. So at that point, you could contact an attorney and say, we have this ongoing case. I've been doing it all on my own. We're getting property. can we hire you to come in and do this? So you can certainly do it from the beginning or do it later. Another thing you could do is just have an attorney from the beginning, get everything set up, and then tell the attorney, thank you very much. I'm going to carry this forward until we get some property. Because I know it's costs are tough when you have a child with special needs. And this is adding another component that most parents wouldn't need. They wouldn't have to worry about attorneys. Okay. Do we need to wait until they turn 18? So the statute says you can file it when they're 17 and a half. But I've had pushback with people try to get it so let's say they turn 18 on the 19th, they get appointed on the 20th. That would be the ideal situation. For my own child, I had like a 3-week period where it was just, there was nobody in charge. Some of the court, again, per statute, you're supposed to be able to do it, but I've always gotten pushback because they don't want the attorney to contact the person while they're still a minor, because they're still under your care. So my suggestion would be, what I try to do with my clients is we get all the paperwork done and ready, and then we file it like a week or two before they turn 18. You can call 6 months in advance, get all the information together, and then file it. But unfortunately, there's probably going to be a period where, God forbid, something happens, you're going to be nervous. Let's say something happens to your child during that period and you go to the hospital. There is a healthcare proxy statute that you as a next of kin are allowed to make medical decisions. So don't ever think you're going to go to the hospital, your kid needs stitches, or it doesn't have to be terribly tragic. They will allow you to make decisions for them. Let's see, we got anything else?
If you scroll down to the bottom, there's 2 other questions.
Okay, so here's a good question. What happens if you are a parent and an advocate and then you want to appoint a sibling? So we have something that's called a standby guardian advocate. What that means is you're appointed as the advocate, but you want someone on deck for you, if you will, for baseball terms. You would file a petition to appoint standby guardian advocate, which I'm assuming would be the sibling or your other child. They would do the petition, they would do the background check, they would go through the same steps. An order appointing standby guardian advocate would be entered, but you would still be in charge. And then if at any point you wanted to convert that to a regular guardian advocacy, you would just petition the court. You still have to go through the process every year when you're a standby guardian advocate. They still want you to do your application, do your background check, etc. There's also something called a pre-need guardian, which is, we can talk about another time. That is determining if you're not able to be the guardian, who you would want to be the guardian. Okay, what's the difference between a durable power of attorney and a guardian advocacy? A durable power of attorney is something that you, the person would sign, giving the right to somebody they pick to make those decisions. So you have to understand what you're signing, who you're appointing, what it all means. So if you have a developmentally disabled child that you think needs a guardian advocacy, they probably don't have what they call capacity to sign that document. So if you have a durable power of attorney that they've executed and signed, you don't need a guardian advocacy. Same thing with the designation of healthcare surrogate. If they understand and they can sign something, then you don't have to do a guardian advocacy. There's a new statute that came into effect July 1st that we're not going to get into tonight, but it's called supported decision making. And that's been, it's another layer. It's that the person decides who they want to help them to make decisions. It's not giving the parent the rights, but it's formalizing, hey, I want mom to be able to be with me at the doctor, to talk to the doctor, to make decisions. So it's kind of an in-between of the guardian advocacy and the power of attorney healthcare surrogate. Let's see. Okay, do power of attorney documents have to be submitted to court? In general, no. They stay with you. They are given to the people who are going to act as what you called your agent in fact. If you're doing a guardian advocacy or guardianship, they have to be submitted to the court. But if you're able to have your child or even yourself do your own power of attorney healthcare surrogate, those are private papers and they do not need to be submitted to the court. Okay. If your child has a mental disorder not listed in the requirements of guardianship, is that power of attorney? Okay, this is kind of combining a few questions. So for guardian advocacy, you have to have one of those developmental diagnoses. Guardianship is where there's a medical exam and your child is determined to not have the capacity to execute some rights. If they're able to understand what they're signing and they're in agreement and they are really the client when they're asking to designate their power of attorney. If they're in agreement with that, the power of attorney, they can sign that and determine who they want to make their decisions. Okay, so I missed the first few minutes of this. I'm an attorney and have quite guardianships. What if I think a guardianship is more appropriate? Is there a mechanism to essentially downgrade a guardianship to a guardian advocacy? There are two different statutes. So I've tried to do this and I was not successful. I honestly don't know if what you could do in the guardianship is do a restoration, suggestion of capacity and have an examination done for some of those rights. You'd have to, it's hard. So let's talk about autism, right? It's a spectrum. So one of my very first cases was actually I was court appointed attorney for a young man with cerebral palsy. Okay, great, check. He's in 393. We can do a guardian advocacy. When I met the young man, he was totally nonverbal, 100% assist. He didn't qualify for the guardian advocacy. Same thing with autism, it's a spectrum. So there are some that are very high functioning and there's some who a guardian advocacy really wouldn't be enough, that they need the guardianship. So you'd have to, if you already have a guardianship, you'd have to do a suggestion of capacity and try and also file in a petition to appoint guardian advocate. I wish I had a better answer, but I really don't know. I've never encountered that. Trying to see, did I get everybody?
Yep, we don't have any other questions in the chat box.
One more comment. You got 3 weeks until his 18th birthday. So definitely, that's a great segue into this. So this slide, and I think you said, Jen, you're going to put the links up there. So my suggestion is this: when I first started researching this and getting into this, do a Google search, Guardian Advocacy Florida forms. A great resource is Lighting the Way to Guardianship. It's put out by the state. I forget what agency it is. It's a thick book, but it's almost like a textbook that talks about guardian advocacy, power of attorney, healthcare surrogate, guardianship. That's a really good resource. Looking at the statutes, 744 and 393. It's a lot of legalese, but that's another resource for you. Like I said, do a Google search, Guardian Advocacy Florida forms. The 8th and 9th Judicial Circuit, which I believe are Orange County in Central Florida, they have all the forms online. They have, and one of the counties has them in Creole, in Spanish, like in Russian, all these different languages. They have handbooks. They will walk you through it. They will have the forms. I know here in Broward, you can go to the clerk of courts and say, I need guardian advocacy forms. And they give you a little slip of paper and they direct you to the law library where you can go and make copies of the forms and then come back when they're filled out. Disability Rights Florida has a lot of resources. And then the Mental Health Association of Central Florida. I also want to point out, I did a lot of research on Facebook. Facebook is so great. I was able to connect and be accepted to a lot of the groups around the state. I found Central Florida, Southwest Florida. They have a lot of great information, and reaching out to a network like that, especially as a parent, it's really good to be with others who understand what's going on. With my family, CARD, it's the Center for, I think, Autism-Related Disabilities, was a huge help for us. The local colleges have those programs. I went through Nova Southeastern. I know UM has one, UF, UCF, USF, Florida State, and hopefully I'm not leaving anybody off. But that's a really, Google will get you a lot of information.
I just dropped those 6 links again into the chat box for everyone that you talked about.
Okay, great. So I just want to take a quick look at, I didn't get to look at what the surveys are. So the biggest concerns, the legal requirements, it's really difficult because our biggest resource before they turn 18 is the schools. And especially if you're in public school, they don't provide you this information. One of the best things about being involved with this, and especially being involved with the parents, is what I've learned from the parents. I didn't know what the PACE program was. I didn't know what APD was. There's all these different programs that unfortunately they're not all just in one place. So I 100% understand the legal requirements. The cost involved, if you have to hire an attorney, it's not cheap. So I can 100% understand that. I'm going to give a shout out to Talia Rangel, who is here from Nova Law School. They have an adult, I forget what it stands for. It's AIDD, Adults with Developmental Disabilities. They have a clinic that assists families who are looking to do the guardian advocacy. They will help you and stay on the case until you are appointed. Check your local law schools to see if they have any type of clinics to help, because I know St. Thomas, where I went to school, now is getting more into that. So reach out to your local law school and see if they have any clinics or anything to help adults with developmental disabilities. Yeah, the big 82% said, do you know someone over the age of 18 with a disability? I think in this day and age, we all know somebody. Be it a family member, be it a friend, be it, it's very prevalent. And especially now, they're coming of age. So, 20 years ago, you wouldn't have known as many, and the guardian advocacy wouldn't have been quite as important. But now these people with these diagnoses are growing up, and they need the help. Okay, so we got a mix. Some are over 18, some are under 18. Kind of a mix. Hopefully the people who said, how familiar are you with the concept of guardian advocacy, the one who said not familiar at all, hopefully you have learned something from tonight that you can take away. And the majority is parents. I'm not surprised. Like I said, I've been there. So I just really appreciate everybody's participation. My contact information is here. If you want to contact me directly, my email is regina@estateandprobatelawyer.com. Feel free to reach out. I'm very passionate about this, and I love talking with parents. So please don't hesitate to reach out. Also, talk to an attorney regarding your own estate planning. If you have somebody who has a disability, make sure you do the proper planning in your estate plan in order to take care of them. And I think that covers everything. Again, thank you everybody for your participation. This was my first webinar, so I really appreciate everybody joining, and I hope everybody has a good night.
Great webinar, Regina. Thank you.